Hello, my name is Mary Mack, and I'm the Executive Director of ACES, the Association of Certified eDiscovery Specialists. And I want to welcome you to the ACES webinar channel, where we will be having another one of our wonderful educational webinars. This one is sponsored by our Platinum affiliate partner and great friend, Ricoh. And we will be covering some items of high interest. But before we do, just a note that the slides are downloadable in your console there, and then also that down at the bottom is a Q&A tab, and we would love to have your questions. So if the question pertains to what we're talking about in the moment, I'll raise it. Otherwise, we'll save it to the end. But we are quite interested in what you are wondering about and what you're thinking about. And this webinar is going to be on best practices to secure your data and protect your organization. Again, sponsored by our Platinum affiliate partner, Ricoh. And we have with us Chris Dale, who runs the eDisclosure Information Project. He's a writer, speaker, and commentator, and he is a subject matter expert on the topics we will be discussing today. And as well, we have David Levine. He is the VP of Information Security and the CISO for Ricoh USA. He's the chair of Ricoh's Security Advisory Council, and he leads Ricoh's global virtual security team. Our agenda today is the state of security today, cyber threats, reacting to a security crisis, compliance standards, best practices, and then a final round of Q&A. And as I said earlier, your questions are very, very welcome. We're thrilled to have you here to listen to this particular webinar and participate. So, David, tell me about the state of security today and what you are seeing.
Sure, Mary. I appreciate the question, and happy to be on the webinar today with everybody. So, great question, and the state of security today is certainly not what it used to be, right? So, when we think in terms of security events or breaches, it wasn't really that long ago that we really looked at breaches in the context of what was that big breach last year, or the two big breaches that occurred that year, and a lot of press and a lot of discussion around breaches of that nature. And the reality is today, 2018 heading into 2019 here soon, is that breaches are truly a daily occurrence. It's pretty staggering. If you get daily security feeds or you go and look at daily security reports, literally there are breaches occurring on a daily basis, and then sometimes we're seeing reports of multiple breaches a day. And there's some danger in that too, because one certainly doesn't want to view such things complacently, but it definitely sets a different tone. And behind those breaches are, of course, the adversary, which has also changed dramatically over the years. Back early in the day, when people talked about a hacker or an adversary, they really tended to think of somebody in their basement hacking away, trying to break into something for fun, which is predominantly what used to occur a long time ago. But today, what we're dealing with predominantly, although the individual hackers still exist, don't get me wrong, but what we predominantly deal with today in a lot of cases are very sophisticated adversaries, and in some cases, and in a lot of cases, nation-state adversaries. So whether we're talking about China, Iran, North Korea, Russia, any of the big ones, they're highly skilled and they're highly funded. And the other thing is, when we're talking about an adversary like that, that's all they do, 7/24 by 365. And even folks in my team and as a CISO, we've got our daily jobs, and defending the network is part of what we do, but we're up against folks that is the only thing they do. And we're also in a state these days where, quite honestly, even somebody who has no hacking experience can go out on the dark web and for what is honestly a very small amount of money can actually purchase complete hacking application suites that come with tech support and all the help you could want. So definitely a different world today. So relative to that, though, sometimes we still have questions around or get in discussions around, am I a breach? Is my company a breach? Or really, for the purpose of today's discussion, are law firms targets? And the reality is law firms are absolutely targets. So, and it doesn't matter whether it's a small practice or a very large, international law firm. The reality is the data that law firms handle, not only their internal data for their own employees and their own, legal folks, but the customers that they're providing services to. It's really, at the end of the day, it's a treasure trove of data for an adversary. They can use that data in a variety of ways to gain outcomes, whether it's getting inside information on intellectual property, gaining information on pivotal cases or mergers and acquisitions. All of that is certainly good fodder for the adversary. So I would say, as much as anything. And another thought here too is that, it's not always the law firm itself that's the direct purpose of being attacked. If the adversary thinks that the law firm can be manipulated or used as an access point to get to the client, they'll do that as well. So, it's a multifaceted situation today. The last point here on the slide is around what to do when you get concerned about security. And there's a lot of different things. I think we'll probably, as this discussion rolls on today, that we'll discuss a few things that make sense here, but certainly engaging qualified third parties to assist with looking at your security program or implementing a security program is certainly where you would want to get started with that.
Excellent. And Chris, tell us, what trends are you seeing now?
Before I do that, I'll just pick up something that happened came to my attention about an hour before we started this afternoon, which is that which reinforces what David's just said. Foley and Lardner were attacked very recently, apparently. Wasn't somebody after their data, it seems, but a cryptojacker, or possibly a cryptojacker, seeking to effectively use their processing power. So there's more than one reason why one has to be on the alert. Given that David's here talking about the technical side, I thought I'd approach this slightly sideways and look at the interrelationship between security and various other things, the General Data Protection Regulation, privacy, information governance. They're all related, and money spent on one of them has value for the others. Put it its briefest, if you keep less stuff, you're not only more likely to be compliant with GDPR and other regulations, but less at risk in security terms. If you're fit to comply with the GDPR, then you stand a better chance of anticipating a breach or reacting to a breach. It's not just the GDPR, of course. We've recently seen the settlement of a class action against Yahoo, which cost them a lot of money. Later on, we'll talk about the Californian Consumer Privacy Act, which is a different aspect of the same thing, this interrelation between security and privacy. You might also be able to reduce other costs, discovery costs. You might be able to find stuff you actually need, which would be a plus. The worst case, whether it's a breach or whether it's reacting to a privacy demand of some kind or another, that if you don't know what you had, you don't know what you've lost, you don't know who should be notified, and you don't have a plan, then you have a much bigger problem than an organization that has addressed all these things. The reaction when we talked about information governance 4 or 5 years ago was that no one could find an ROI for that. why should we spend money on this nebulous concept of information governance, particularly when there was no product around that was designed to solve an identifiable problem. The rise of security issues, as well as the rise of privacy, have changed the map there, I think. There are more reasons than one, just to repeat myself a bit, for spending money on finding out what data you've got, getting rid of the stuff you don't need, and so on, all of which makes you less at risk and less attractive indeed to any sort of intruder. There's also changing perceptions we're seeing. That ROI question is addressed rather differently now. Cost is not just what you pay out, but what you save. And what you save is not just money, but other things as well. There's a greater appreciation of personal privacy now for various reasons. We're all watching Facebook and Google and the rest, who are watching us rather more closely than we might like. Snowden and the NSA saga alerted Americans in particular, but the rest of the world as well, to the risk that we're at, simply by virtue of the amount of data that's being kept on us, quite apart from anything else. Ethical considerations, which weren't fashionable until recently, are becoming so. Ethics doesn't pay the bills or offer returns to shareholders. But if you're seen as a target, if you're seen as a company that has not organized itself to face security risks, what if your customers leave? What if nobody wants to work for you? What if nobody wants to invest in you? All sorts of considerations arise that go way beyond the loss of data. Companies ask themselves, would you like to do business with a good company? And that's permeating through to boardrooms as something that companies ought to have regard to when they think about spending their money. There's more publicity now about breaches, and I'll expand on that in a while. But mainly, I think there's a changing culture. The GDPR has ridden that changing culture and fanned it. Others are following, but they're pushing it an open door. And the facts that David has just talked about, the ever-increasing number of security intrusions or problems of one sort or another, are all part, to my eye, are all part of the same story.
So do you think that we're seeing more breaches now, or do you think people are just more aware, Chris?
Well, I'm certainly not going to argue with David saying that there are a lot more of them. In the UK, the breach reports are up. Whether that means more breaches or more reporting, I'm not sure. I'm fairly sure that it's both, that there are more breaches and that there are people are more ready to report the breaches than they used to be. Statistically, the UK Information Commissioner's Office reported 2,500 breaches in 2016 to 17, rising to 3,300 in 2017-2018. And that number's still going up. So those are the ones that were actually reported to the regulator, mainly in health, in education, and in local government. What are the answers to this? What are the reasons? Well, one, certainly there are more breaches. Another is that I think it's become acceptable, indeed seen as responsible, to not just to report breaches to the regulator, but to go public about them. It's a bit like alcoholics at a rehab meeting, perhaps. People are more willing to say, yes, I've had a problem, not least because they're likely to be found out anyway. In the EU, or certainly in the UK, there's possibly an element of over-reporting. Organizations feeling that it's safer to report to the regulator than to risk punishment for not doing so, not least because an individual who's been affected by a breach might report them anyway, and perhaps it looks better if you've got your own report in first. There is a genuine fear of regulators and the punishments that they can hand out. But I think also there's better housekeeping. Organizations are paying more attention to their data, probably in reaction to regulation as much as anything. They're devising policies, they're installing better technology, they're recruiting better people, and a general sort of atmosphere of better accountability means that organizations are finding more than they used to.
Interesting. And so Chris, you're focused on data and some technology. David, can you talk a little bit about the human element in security and securing data?
Yeah, absolutely. And before I jump into that, though, I mean, I definitely, Chris is a good point too. I mean, the tools and the technologies that are out there today to detect breaches and anomalies, are substantially better, better in some cases, and quite frankly, just didn't exist not that long ago. So I think, for organizations that have the ability to invest in some of those tools, that the ability to detect anomalies and problems quicker, if at all, again, is much better. Historically, one of the issues we see in breaches, and I think this is shrinking, is we call it dwell time, and that's the length of time between an adversary actually gets into somebody's network and how long it takes you to figure that out. Historically, that amount of time has been, quite honestly, staggeringly long, in some cases up to years to figure out that somebody was in your network. So the technology has really come a long way. That's part of it. The other thing that I certainly see too is, it's not even just whether you're figuring out if you got breached. If you haven't figured it out, somebody else may very well do that, either because of data that's being sold on the black market or the dark web, or a federal agency has made that determination and knocks on your door. So I think there's a lot of different things in motion that contributes to that. But one of the interesting things, though, when we start talking about the human element, is that a lot of times we hear people talk about 0-day attacks and things that have never been seen before, and crazy things that happen that enable an adversary to get into a network. But quite frankly, the reality is if you look at the data, that the vast majority of breaches occur due to really two things. One is unpatched vulnerable systems, and the other is phishing, or a combination of both. The bad guy, the adversary, uses phishing to leverage a vulnerable system. Well, a huge piece of actually both of those elements, quite frankly, are not as much technical as they are human. Whether it's patching and keeping systems current and not vulnerable sounds like an easy thing to do, but the reality is, particularly for a larger organization, it's a challenge. It's hard to stay on top of that. There are implications for patching. Sometimes you have negative unintended consequences, and so the cycle time to figure all that out and put patches in place can leave systems open. Not always understanding, or I should say, if you don't understand everything you have, it's also difficult to keep everything current. But people are a huge factor. Everybody potentially has a bad day. So it's not uncommon for even people that typically wouldn't click on a phishing message to, over a long period of time, may very well be susceptible to doing so. So part of that's a technology thing, and trying to have the tools in place to help minimize the likelihood of a phishing email being effective. But the reality is people are complicated. And driving a security culture, and we'll talk about this a bit some more, but driving a security culture inside of the firm or your company is really critical these days. And it's really hammering home that message that security is everybody's responsibility. Now, Ricoh is a huge corporation, but my security team is not huge by all comparisons. And so, I know internally here, I try and drive that message that security is everybody's responsibility. Everybody's part of that security team, right? Because it doesn't take much. It really, quite frankly, only takes one person to click on a phishing email that, if for whatever reason your technology doesn't have the ability to mitigate that risk, to really cause some enormous issues. I mean, we've seen We've seen firms and other companies have pretty substantial impacts due to things like ransomware. And again, that usually comes back to somebody clicking on something they shouldn't have. And in some cases, it can be a difficult thing. And what I mean by that is if an adversary is targeting an executive or an executive assistant or a paralegal very specifically for a specific reason, there's a pretty high likelihood that they may be successful. Some of the campaigns we've seen against individuals are very sophisticated, very well done, and they're really relying on somebody to not take the time or to basically make a mistake and click on something that they shouldn't have. So people can really truly be one of the most difficult things when it comes to security because you've really got to change their mindset and not change it on a temporary basis. You have to permanently ingrain in people that security matters, and it matters every day and with everything they do.
That is ever so true, and especially when you consider that we're all encouraged to email each other, to click on links in emails. And as you were talking, I was just designing myself like a way that we can maybe have our newsletter in a particular place on the web that people can just go to without having to click in an email. So I think all of us are going to need to do a little privacy by design. But when you're talking about reacting to a security crisis, what do you think is the most important thing to do before the storm hits?
So from a planning standpoint, there's a couple of different things, I think. So one is you got to have a plan. I think that's 101, and it seems like that's a really basic, logical thing to say, but people don't always plan for something like that. So having an incident response plan and knowing what you're going to do and how you're going to do it when the bad thing happens, because quite honestly, we really don't talk in terms of if you're going to be breached. It's really a matter of when and to what extent. And so you really need to know what you're going to do. And there are a lot of different ways you can do that. You can you can contract with a third party to come in and help you design an incident response plan, or you can craft one yourself. There's a lot of good sources out there. But once you have that incident response plan in place that really says, how are we going to maneuver through this? But almost more importantly, who's going to be responsible for what? Because believe me, if it's a significant breach, when that happens, everyone's going to be in panic mode and everyone's going to be scrambling. And what you don't want to be doing at that point in time is trying to figure out who's going to talk to the media, who's responsible for making a decision about shutting systems off if that's something you need to do, who's got the action item to reach out to law enforcement if that's applicable. You want to have all that defined ahead of time. And to that point, you also want to practice. So have the plan and practice the plan. And there are different ways you can do that practicing. But whether it's a tabletop exercise where you basically have mock breach scenarios, and everyone gets that opportunity to role play and figure out what to do. Again, you can have third parties come in and help you orchestrate that. And in some cases, there are some actual organizations that you can actually go to their facility and they'll actually do very elaborate breach scenarios. And again, you walk everybody through it. So I think those are key. Other than that, again, driving a security culture, is part of planning for that. Doing phishing tests, or we do that on a regular basis. We phish our own employees. That's actually always quite an interesting thing. It really, I'll spend a minute here on phishing because I think it's important because it helps people get into the pattern of evaluating emails, understanding what they need to look for. But it was interesting when we started doing it several years ago. We actually had some negative feedback to begin with. I mean, I'll be honest, our employees were not too happy that we started phishing them. They actually thought we were kind of being sneaky and underhanded. But that just showed, how much opportunity we had to work with our employees and educate them. And it's really shifted over time as we've continued to run those phishing campaigns. And quite frankly, we almost never hear anybody who's being negative about it, and quite frankly, the opposite. We've had emails from employees go, "We're on to you. You need to make them more difficult," which of course we're happy to make them more difficult and more realistic, but it really does give you that opportunity. So that's part of your defensive posture. But again, going back to really planning for a crisis, I have to go back to those two things. It's having a plan and practicing that plan.
So Chris, how can compliance regulations make you better prepared? Like, I imagine the GDPR has lit a fire underneath people to get
Well, absolutely. Absolutely. Before I do that, Mary, can I bring forward something that's sort of later on my list because it follows on from what David's just talked about on the handling of cyber breaches. He's talked about, and rightly, about, as it were, wargaming it and planning what you're going to do and the technical side of things. A side that often gets overlooked is the public relations side. Sure, the first thing is to deal with the crisis, but you've got journalists, you've got customers and shareholders and staff all demanding to know what's happened, quite apart from the regulator. There may have been a company that was about to do business with you or a company that was about to acquire you or whatever, and they see often a publicity shambles. British Airways, with whom I travel a lot, had a disaster a year or two ago that wasn't actually a cyber disaster. It was a consultant who pulled the wrong plug out of the wall, and the whole computer system went down for days. It was badly handled in technical terms because it was clear they had no failovers, no fallback systems, no technical answer. But they also didn't have a PR answer. The CEO looked completely daft, shoved in front of the cameras to try and explain something he didn't understand. Interestingly, British Airways is one of the recent victims of more conventional hacking, and they made a much better job of it. They'd clearly learnt something from the lesson, and were out very quickly explaining what had happened. I think they offered compensation of some kind fairly quickly, reporting not just to the regulator but to the world. And it looked as if they'd learnt that lesson, which, as I say, also reminds us that it's not just cyber threats we're talking about here. Something as simple as somebody pulling a plug out of the wall can have an even bigger result, a deleterious result that needs to be reacted to in much the same way. Another point that David made that I think is worth, and a very good point, which is worth expanding on, he made the point that attacking a law firm is often a way of reaching to the client. The law firm, perhaps for discovery purposes or for M&A purposes or whatever, has gathered together the cream of the documents relating to a client's matter. And if their security is not good, they can reach to the client. Another thing we're hearing is people going beyond that, reaching to suppliers and suppliers' suppliers. Once they get in, the ability to fan out across the wider network, not just the internal network, and see who does business with you and perhaps take advantage of that is another reason for worrying about security. Come back to your question, which is what's the interface between regulations such as the GDPR and defending yourself against hacking cyber events of one kind or another. The most recent one we've had over here has been, it's affected everybody, but it's focused particularly on Europe, is the Facebook hack, which apparently affected 30 million users. 3 million of those, 10% of those, were in Europe. And this is going to be the first big test of regulatory control or reaction to a cyber breach since the GDPR came into force. Facebook were fined over here £500,000 recently for their dealings with Cambridge Analytica, £500,000 being the maximum they could have been fined under the old rules. That wasn't a third-party breach. That was the charge against Facebook, that they facilitated wrongful access by third-party developers to the data which they hold. It will be really interesting to see what the regulator makes of Facebook losing access or giving access to 3 million European data subjects data under the new rules. We're fairly clear, I think, that the very high fines that were put into the GDPR weren't for everyday organizations. They were there because to make an impression on Facebook or Google or any other of those very big companies, you've got to have a very big fine. And the investigation, no doubt, will look at culpability of Facebook in looking at this hack, as well as and at the actual facts. Going back one, what provisions does the GDPR give that empower the regulators to investigate and place extra burdens on companies? One is what's known in shorthand as the storage limitation provision in Article 5 of the GDPR, that data is to be used only for the purpose for which it was created and is to be deleted when it's no longer required for that purpose. So if one needed an incentive to undertake selective deletion, the fact that there is a law which requires you to get rid of redundant data adds an incentive that was missing when we used to have those discussions about deletion when IG first became talked about. That raises all sorts of interesting questions. How does deletion under the GDPR fit with US legal holds, for example? How does it fit with that idea that you should keep everything just in case, that lawyers are always wishing on their US clients? Just in case of what, one should ask? Well, now it might be just in case the GDPR comes along and says you shouldn't have been keeping this data anyway. So there's some interesting conflicts likely to turn up there. The other one is Article 15, the right for data subjects to access their data, their right to have copies of it via subject access requests, to which you must reply within a month. Data subjects can demand rectification. They can demand erasure of data that you shouldn't be holding. And the principles here are much the same as with security breaches. If you can't report on what you don't know about. You can't provide what you can't find. And this know your data idea spreads, as was my opening proposition in this webinar, across a wide range of subjects. If you're doing it for one reason, well, do it for security as well. It's an easy hit in budgeting terms to be able to point to not just GDPR fines, but also to the PR downsides of getting it wrong. Perhaps I could add to that, while I have the stage, as it were, that fines are often the least of it. That may be different under the new rules, but there's a UK company called TalkTalk, which was the subject of a breach a couple of years ago. They were fined £400,000, which was high under the old rules. The customers they lost, the market share they lost, and the amount of work they had to do to resolve it all cost them a great deal more than £400,000. So fining has hitherto, anyway, been the least of it. We're hearing that regulators are saying fining is not our primary function. What we want to do is to make recommendations for future conduct. We want you to tell us how you're getting on, what progress you're making. 30% apparently of complaints made to EU regulators have resulted in no action at all. Companies may not even know that the complaint has been made. Nevertheless, the whole culture of privacy, and not just the GDPR, is inevitably driving a much closer attention to what one should be doing with data, and that has merits for security reasons as well as for privacy ones.
Exactly, Chris. And I was speaking with some panelists in Detroit a couple of days ago, and they were detailing the various breach timing for reporting. And the 72-hour notice had audible gasps. One would think that everybody knows about that now, but what does it really mean?
People misunderstand that 72 hours. They think, and by they I generally mean people who are selling solutions, that you must report everything, every last detail within 72 hours or you'll be punished. That's not what it means. What it generally means, or is thought to mean, and bear in mind here that the GDPR is new and we have yet to see what position regulators are taking on it, but their published reaction, the regulators' published reactions to this, is they want to know that something has happened. They want to know how it happened. They want to know the scale of it. But most importantly, they want to know what you're going to do about it. And that, at least in very broad terms, and that's what you are required to do within 72 hours, or indeed within a reasonable time. There's not precisely 72 hours. That doesn't make it any, it makes it less onerous in terms of the volume of work you've got to get through. But it still it makes it incumbent on companies, at the very least, to know that they've been attacked. One of the points, the very good points David made earlier, was that there's a long interval between an attack happening and organizations knowing that it has happened. And whilst the 72 hours runs from the point at which you should reasonably have known that you've been attacked, effectively, there's all sorts of other reasons beyond the regulatory ones for wanting to know that as soon as possible. The technology, as David said, is getting better all the time, including better and better technology for identifying in real time that you're the subject of something that shouldn't be happening, to put it in the most neutral terms. One of the things we're seeing is a sort of arms race, I think, where the hackers get better as the technology and the systems and the resources get better. And almost as a challenge, I think. It's not just they want to make money out of it. They seem to find a pleasure in defeating the latest iteration of defenses that organizations have put up. And that's driving better technology. And the existence of the better technology perhaps drives a higher responsibility. If you could have acquired systems, software, people to allow you to deal with, to anticipate or to react to a breach of whatever kind, then perhaps you should have bought it, depending on your size and all the rest of it. And it's much the same as happened in eDiscovery. Technology got better, and courts began to expect a higher standard from firms dealing with discovery. And therefore, then the technology became better again to deal with the court's higher standards. I think we're seeing much the same in cybersecurity technology, a cycle that's in a sense a virtuous one, but becomes kind of expensive if every time you buy something or invest in systems or people, the hackers find a way around it and force you to go out and invest still further. That, however, is where we are.
Interesting. And in the GDPR, one of the aims was to harmonize the privacy laws in the EU. And I think we can argue whether that has actually happened or not. But what do you make of California's foray into privacy, the 2020 Privacy Act, the Consumer Privacy Act?
Well, it's interesting and different in some ways. It's interesting also, and if we're just sticking with California, that Yahoo settlement I referred to earlier shows that you don't have to wait for a California Consumer Privacy Act to have rights given to affected individuals to bring claims. That was a class action which cost Yahoo and its partners $50 million in compensation, another $35 million for lawyers, etc. And one of the factors that influenced the size of it all, I think, was it was a state-sponsored breach. It happened in 2013. It wasn't disclosed until 2016. So even before we get to the California Consumer Privacy Act, there are rights in the hands of those who've suffered. The California Act is still in draft. There's still stages to be, or there's still scope for arguing about what it's actually going to say, I believe. There are, as it stands, no new data breach notification obligations in it. But what it does do is create, if it needed to, a private right of action for consumers whose personal information, and I'll quote here, is subject to an unauthorized access and exfiltration, theft, or disclosure as a result of the business's violation of the duty to implement and maintain reasonable security procedures and practices. So there we have it square on. Organizations have a duty, the Act is saying, to implement and maintain reasonable security procedures and practices. And those who suffer, and again I'm quoting, unauthorized access and exfiltration, theft, or disclosure, because they haven't done that, have effectively a new private right of action to sit alongside their existing class actions of the kind that we saw with Yahoo. So there's much more to the CCPA than that. But that, I think, is a point that's most relevant to what we've been talking about on this webinar.
Excellent. David, what are you seeing about what measures organizations should take in the light of the U.S. states getting into privacy? What standard do you use in the U.S.?
Well, that's a great question. I mean, so as far as what standard we use, I think that actually varies considerably by company, and there are a lot of different compliance and governance frameworks out there. So you really have to take a look at your business and the data and the relationships you have with not only other companies but other countries, and really decide what's the best fit for your organization. I mean, certainly, GDPR, which we've been discussing, if that's applicable, obviously that's one that obviously everyone is digging into and has been. But you've got a couple of varieties of NIST frameworks. You've got ISO 27001. If you happen to be dealing with or related to medical, HIPAA and HITRUST, and there's a lot of overlap between some of those frameworks and governance standards. But really, again, it's really got to be a decision based on your business and the type of data you hold.
So
people are always seeking.
Go ahead, Chris.
Sorry, I was going to say people like to have bright lines that they know whether they're stepping from being a good organization to being a bad organization, and that applies as much to security as it does to discovery. The nature of certainly the GDPR, but I think also of other similar legal inventions, as it were, is that there has been deliberately left room for the thing to grow and change as the world grows and changes, and that discomforts people. It means it's hard to say, I have stepped from being good to being bad. But it also means that as technology develops, as threats develop, as notions of privacy develop, so the application of this legislation can develop with it through regulatory decisions and ultimately through court decisions, which, as I say, discomforts many who like a bright line to tell them where they're going wrong.
So, as we're rounding the bend on this particular webinar, what best practices or what community practices can you offer our listeners so that they can be better prepared for the zigs and zags of legislation, court cases, and the ever increasing numbers on the one hand, and then sophistication on the other hand of the people trying to get in?
So I guess I'll tackle that first from the security perspective in general. And what I would say is, bear in mind, it's not a single thing, right? There's no silver bullet to protecting yourself, your law firm, your organization. You've really got to develop an ecosystem of a variety of things. So your security ecosystem should be about driving that security culture, which again is about education and buy-in and getting people to understand the role they play, the importance of security. And I would, I should have said this earlier. The other thing is, when it comes to security, you got to talk in terms that the business understands or the firm understands. So put it in the context of risk or clients or profit or whatever happens to be most applicable, but translate that into risk, because at the end of the day it's all about risk mitigation. But it's building an ecosystem of tools, because it's definitely a piece of the puzzle. Compliance and governance standards are an overlay that can drive improvements. As Chris was talking about, there have been some real tangible benefits to things like GDPR. That's part of the puzzle. Education and awareness is part of the puzzle. Processes, that's a piece of it too. And all of these things combined, really create, again, a complete ecosystem that helps protect, protect your environment and your clients and your customers. Again, there's no one single thing. I guess the other thing I would say is sort of a guiding principle, and I think, Chris, you touched on this early on, is you got to know what your data is. If you don't know if you don't know what your crown jewels are, if you don't know what your critical data is and where that data sits, you're going to have a really difficult time wrapping that ecosystem around it to protect it. So, if somebody's really sitting here kind of with a blank sheet of paper and trying to figure out where to go first, figure that out first. Where's your critical data? Where does it sit? Who has access to it? And you can start wrapping controls and programs around it.
Chris, that sounds very much like the identification phase in the EDRM. Know what data you have. Do you see overlap between e-disclosure, eDiscovery, and security?
Yes, indeed. The one has grown out of the other to some extent. I think it's worth making this point. Anyone who says this is easy is kidding themselves and you. There is no single answer, as David has reiterated. There's a lot of people out there selling snake oil for the people who purport to sell whole GDPR solutions. There was one over here not so long ago who claimed to have met with the GDPR as if the GDPR was a corporeal entity of some kind. So it was easy to identify that one didn't know what he or she was talking about. If one wanted to reduce it to 3 words, then keep less crap is perhaps the shortest way of putting it. What David said about identifying your problem areas is absolutely right. There's also a case perhaps for, it's not an expression I like, but it's useful, identifying the low-hanging fruit. What risks can you buy off with an immediate investment or immediate attention that may not be the biggest risk, but they are at least addressing something of the problem. The regulator is not going to be impressed because you've solved some minor problem that actually doesn't solve the problem. But they will take note of the fact that you've tried, as it were. That doesn't mean they won't measure what you tried to do and whether it was worth doing or had any effect. But the organizations who have done nothing are going to get a harder time than those who've tried to do something. Buy the best technology you can afford. Hire good people, not just the staff that you keep on board, but the consultants. Identify the ones who actually know what they're talking about, because there's an awful lot out there who don't.
Interesting. And so, as we're looking at this, Chris and David, what are you seeing when you hear about the 4% fines, the 2% fines? I think you mentioned earlier that wasn't a given. It was just for the larger organizations. Are you seeing that there may be some ways to mitigate those fines moving forward with processes and procedures to protect?
I think it's very unlikely, and I had a 2-year battle before the GDPR was implemented with those who just said blandly, you'll be fined 4% of your global turnover, as if that applied to every minor defect in policy as well as to major breaches. We have yet to see, but I am reasonably sure that the 4% figure was put in there because companies like Facebook and Google really don't care too much if they get fined small numbers. Somebody calculated that it was going to take Facebook 15 minutes to earn back the £500,000 that they were fined for the Cambridge Analytica event. So clearly something bigger is needed for mighty organizations like that who, so far as one can tell, really don't care very much. It seems to me equally unlikely that a mid-ranking or even large organization who has tried, who has suffered an attack which, yes, might have been headed off by better procedures or whatever, it seems to me unlikely that they're going to be the target for the very big fines. Bear in mind, for example, that Facebook is a data company. It's not just a company which happens to hold some data. Its whole business is keeping people's, in some cases, very private data. And that imposes, to my eye anyway, a higher test on them than an organization which, like all organizations do, hold data in the general course of business. It's also fair to observe that the Cambridge Analytica thing was appalling conduct, not just a failure to do the right thing or a slip up in the failure of technology or a misjudgment by somebody. It was very much doing the wrong thing or facilitating somebody else doing the wrong thing. And I think we will see a division as fines start being handed out between those who made mistakes of whatever degree of culpability and those who did the wrong thing.
David, as you've been working in the security field, are you seeing more listening on and more interest on the part of the executive teams to address security? Where I think before it was more, if I don't see it, I don't have to deal with it. What are you seeing across the industry there?
Oh, absolutely. Yeah, no, it's definitely come a long way. You're seeing now CISOs with a seat at the board on a regular basis, whether it's report out or a security committee. You see executive management teams asking regular questions. Certainly even in my own personal experience, it's definitely changed over the years. I now have a handful of quarterly report outs to different committees and different executive management teams within the company, both in the Americas but also globally from a security perspective. So, I think it can vary by organization as well too. Again, if you happen to be in a company that's highly regulated, you certainly you can see more of that as opposed to a company that may not have any specific fall under any specific regulations. But regardless, the trend has definitely increased. I think most executives and CEOs today are concerned about their data, about their security. They see the breaches, and they want to make sure that they're doing the right thing, not only for their company but their customers.
And for themselves, one might point out, because if you're the one who should have done something and didn't, then you're likely to be swept out in the rush, even before anybody starts thinking about whether you were truly culpable or not. The finger will point at the person who had the job title, which implied that was their duty.
Oh, absolutely. Yep.
Indeed. Well, we're up at the top of the hour here, and we have time for one more question. Well, what I see here, Chris, is a question about, are you seeing an increase in interest in security in the EU because of GDPR? There's always been an interest in privacy.
Yeah. The answer is, well, we're certainly seeing an increase in interest in security. How much of that is attributable to the GDPR and how much of that is attributable to what was David's very first starting point, there are more attacks, more breaches going on, is quite hard to say. Why does somebody make a decision? If you follow the analysis that I made during this webinar, it's because the money spent on one thing can be used equally to defend against another. And one would need to get down to sort of organization decision-making level to find out why an investment had been made. So I put very roughly, I'd say that there's been equal, the GDPR has been a driver co-equal with the growing number of threats. For reasons apart from the GDPR, if you see what I mean.
I do. Well, thank you, Chris, and David. This is a perfect storm. Regulations around privacy, regulations and actual breaches around security, in with the crown jewels of data being housed for very highly confidential purposes. So thank you very much for sharing your expertise with us, both of you. So we will be communicating with everyone on the webinar and make sure that you have a link to the presentation and the slides. We thank you all for your kind attention today. And David and Chris, we thank you very much for sharing your knowledge. And we thank Ricoh for being such a fabulous platinum partner. We look forward to seeing you again on the ACEDS webinar channel. Thank you.